Acquiring a landed property is one of the smartest investments one can ever embark on, but inadequate understanding of the required documents and titles to look out for when acquiring these properties can lead to a legal dispute that might cost one a fortune or loss of property. One missing or incomplete document can lead to problem one never bargained. Therefore, in this video, I will be breaking down the different types of land documents and titles to look out for when acquiring a landed property. Hi, my name is Cosmos, your number one property consultant, and I partner with a real estate company called B1. And in this channel, I always bring to you educative content on real estate and property management. If you're new to my channel, I would like you to share, like, and subscribe to get more videos like this subsequently. So let's begin. First of all, what are land documents and titles? Land documents and titles are legal documents that shows or proves that a certain individual or an organization are the rightful owner or the rightful occupant of a piece of land or a property. Or it can say to be legal instrument that shows the transfer of right of ownership of a property to an individual or to an organization. Now, before we dive deep, we are going to be looking at title documents. There are 5 types of title documents to look out for when acquiring a landed property. And number 1 on the list is certificate of occupancy. Now, certificate of occupancy, also known as C of O, is considered to be the strongest among other title documents, and it is issued by the state government through the Ministry of Works. Now, obtaining a certificate of occupancy is a way of taking a step further in securing your landed property. It's a way of getting the government involved and the government approving that you are the rightful owner of a property, and it can only be obtained when you have already acquired your property. Now, number 2 on the list is right of occupancy. Now, the right of occupancy is a title document that gives an individual the right to occupy a property or a piece of land for a certain period of time. So it is time-based, and it is only issued by the office of the local government where the land is situated. Number 3 on the list is a registered court order. A registered court order is a title document that is issued by the court of law, especially if the property went through legal dispute. Let's say, for example, 2 persons are fighting over a piece of land and they decide to go to court. When one party wins, the judge will now assign the right of ownership of the property to the winner of the case. All right, so the document signed by the judge now serves as a title document. Number 4 on the list is a governor's consent. A governor's consent is a title document that is issued to an individual through the office of the governor, approving the transfer of right of ownership of a property to that individual, especially if the property comes with a certificate of occupancy. And number 5 on the list is accession and gazette. Accession is the process whereby the government assigns a portion of a piece of land or a property to an individual or to an organization to own, while gazette is the official publication by the government indicating the release of such property to that individual. Now, these are the 5 types of title documents to look out for when acquiring a landed property. Now we are going to be looking at other land documents, and there are also 5 of them. Number 1 on the list is deed of conveyance, also known as deed of assignment. It is a legal agreement where the assigner, which is the seller, assigns the right of transfer of the property to the assignee, which is the buyer. And there are different features that are to be captured in the deed of assignment, which include number 1, the names of both parties in question, the name of the buyer and that of the seller. Number 2, the address of both parties. Number 3, the history of the land in question, how the land was obtained till the very moment it is about to be sold. Number 4 is the agreed cost of the land and the willingness of the seller to sell at that price. Very, very important. Number 5 is the size and the description of the land. Number 6 is the oath or the covenant both parties agreed to undertake in order to perfect the transfer of the document. Number 7 is the signature of both parties and that of other 2 witnesses to the transaction. And number 8 is a section for governor's consent. Now, these are the features that are to be captured in the deed of assignment. Number 2 document to look out for is a registered survey plan. Now, a survey plan is a map that shows the size, the location, and the boundary of a piece of land. But it goes beyond just being a map. It can also serve as a legal document to prove that an individual owns a piece of land, especially if the survey plan passes through the office of a registered survey general. All right, and with the description and the coordinates of a survey plan, one can use it to find out if the piece of land or the property falls under government acquired property. Please, whenever you're purchasing a land, make sure you are not buying a piece of land that falls under government acquisition in order to avoid government wahala. Now, number 3 on the list is land purchase receipt. Now, land purchase receipt serves as a proof of payment, as simple as that. And number 4 on the list is contract of sale. A contract of sale is a legally binding agreement between the buyer and the seller outlining the terms of transaction involving the transfer of goods, service, and property. Basically, it is a documented agreement on the mode of payment. So if the buyer is purchasing the land outrightly, if he's paying an outright payment, it has to be documented. If the buyer is purchasing instrumentally within a specific period of time, it has to be documented. If he is purchasing the land through rendering a service or supplying of goods to the seller, it also has to be documented. Number 5 on the list is grant probate and letter of administration. Now, grant probate is a legal document that confirms that the will of a deceased landowner is valid and gives an executor the right to administer or distribute the property of the deceased landowner. While letter of administration is a legal document that gives an individual the right to manage the property of a deceased landowner who died without a will. And these documents plays an important role in the transfer of land ownership through inheritance. Now, these are the types of land documents and titles to look out for before acquiring a landed property. I will encourage you to go through this video once again to get yourself acquainted with the different types of land documents and titles to look out for before purchasing a landed property. And this is all for today. Until I come your way once again, I remain your friend Cosmos, your number 1 property consultant. Remain blessed.